I'm just going to tell you that he's going to talk about the question of judicial delays in a comparative perspective. That's his title. It's a very broad one, and it was actually your task to find something for yourself or from your own perspective under this title and present something interesting to us. So Michal, what I know Michal, I've known Michal for a number of years now, but as I was preparing for today's lecture, I came across his CV, and since this is so long, I will have to read it out to you, what he's achieved so far.
You can also skip it, and we will have more time for the lecture.
Are you sure? Yeah. No, I'd just like to mention that Michal graduated first from the Charles University in Prague, in Law and International Relations. Then he did a variety of courses in a variety of places. He also graduated from Oxford University, he holds a diploma from Cambridge University, and he did his PhD at the European University Institute in Florence. He works in the field of European law, we could say broadly defined, focusing especially on courts, judicial dialogue, but especially at home in the Czech Republic, he's also been active in the public discourse and the public dialogue, discussing the ups and downs of the Czech transition from the communist system to democracy. Michal is now a professor at the Collège d'Europe, College of Europe in Bruges. He's a professor of European law. At the same time, he's still simultaneously a fellow at the University of Oxford in the UK. He's written a number of articles, edited and written a number of books. I guess what it says, 9 books. But the most important book is still coming. It's forthcoming, and that's his book that will be developed from his PhD and will be published by the Oxford University Press in August this year, right? So Michal, it really is a great honor to have you here, and I've spoken too much, I've spoken enough, and the floor is really yours now.
Thank you so much. Good afternoon. I see you did have a quite sharp start, because he has been here for 10 minutes, already given you homework. But I hope you might survive that in your little writings. Thank you very much indeed for having me and for the kind invitation. Speak about judicial delays in 1 hour, it's indeed a difficult task. I understand it's part of the drive to avoid academic delays when talking about judicial delays. That's why I got 1 hour. But, well, the question that in the end you will be entitled to just satisfaction for having to listen to me for 1 entire hour, we can leave open. But as was already said, I mean, to say something useful on judicial delays in 1 hour is rather difficult. And as I understood from the program of the things which awaits you in the forthcoming days, that you will have a number of sessions on specific points dealing with delays, length of proceedings, looking at the various courts and looking at various solutions. What I thought might be quite useful to you is trying to give you the sort of bigger picture. To look at the national level meaning national system, national courts, leaving aside international courts, European Court of Justice, European Court of Human Rights and so forth, looking at national court and the national system and putting it really into sort of bigger picture of transition and post-transition. Looking essentially at 2 questions, which I tried to schedule out. Did you receive the outline together with the articles? Yes. Some of you at least? So this is the general idea I would be developing, looking at 2 things. Firstly, why have we got where we are? So how did the problems start accumulating, and why in a number of Central and Eastern European countries these days we do face considerable judicial delays? And secondly, in the second strand of my talk, I would like to offer at least some indicative experience and ideas about possible ways out. Meaning, what to do with excessive delays, dysfunctional courts, and somewhat problematic judiciary. Now, while doing so, before starting doing so, please allow me to pop in 2 or 3 caveats. Firstly, all I will be telling to you is essentially my rather personal experience, impressions, and opinions. There is absolutely no blueprint out there for saying, oh, if you do this, your judiciary will work excellently. If you implement that, everything will be hunky-dory, and there will be heaven on earth. No, it doesn't exist. There are particular problems and particular solutions to them. So what I will be telling would be rather my study and experience from the Czech judiciary, because, well, luckily, Matti did skip that one. But today I will be rather talking with my judicial hat on, because before turning academic, I actually qualified as a judge in the Czech Republic and worked for 4 years as the legal secretary to the Chief Justice in the Supreme Administrative Court, also heading the Research and Documentation Department. And in this capacity, I did have the privilege of participating also in some of the judicial reforms within administrative judiciary as well as overlay the Czech judicial system, which was extremely instructive and was also a good laboratory. Why? Well, because the administrative judiciary in the Czech Republic is quite new, established only as a separate branch of judiciary in 2003, and it's quite small. It's only 4 to 5% of the overall judiciary which are administrative judges. Some evil tongues say it's the 4% judiciary, but that's not right. I mean, we rather tend to say it's 5% in order to overcome this sort of labeling. But still, and one can play with ideas. It's small, it's operational, and you can introduce new things quite quickly. Also, from the point of view, you have repetitive players. Always, one side is always the state. So you can educate those much better than accidental litigants who come to court once in their lifetime. These are repetitive players. So you can do a number of these things in there. So that's the first caveat, really. It's just personal experience from administrative courts, as well as looking comparatively somewhere else. Secondly, it's mostly limited to Central Europe. By Central Europe, I mean Czech Republic, Slovakia, Poland, and a bit of Hungary in cases I'm able to understand them, which is not very frequent, but it's good. So I have very no idea really about Slovenia or generally about former Yugoslav countries. But reading some of the articles before coming here, so I also did my homework a bit, I had the impression that some of the problems are really recurring and very, very similar, which you face, or one faces, in a state in transition. And as I said, I mean, I'm not able, and you will also see from the outline which I've given you, one is not able to offer any miraculous one solution, right? It's a complex problem, which one may only offer. I mean, there might be a solution once we are able to identify the cause. The cause going back, retracking and saying, well, look, this is where the problem started. This is where the narrow strains. This is where the procedure got blocked. And why? So through the reconstruction, we might come to a certain solution, but there is no universal blueprint for this. And I think we, perhaps you as well, but certainly we in Central Europe, I mean a little bit north there, we certainly learned that miraculous solutions sort of imported, especially from the guaranteed European models. I mean, one-fit-all solution, and if you do this, you have a marvelous judiciary. It doesn't work, really. The problem is that we see daily practice, a number of the solutions which were promoted universally through Council of Europe, through European Union, in the pre-accession conditionality, are essentially a failure in the new member states. Speaking about things like judicial councils, which turned out to be a disaster in a number of transition countries, speaking about various elements of procedure, and so forth and so on. So no one-fit solution, it's really try out and testing method. Okay, with this introduction, let me turn to the sort of first point, the birth of judicial delays, which I think most of you have experienced yourself. I mean, meaning how one started to see the problems accumulating. I try to distill, when thinking about it critically, I mean, how did this happen? How did we arrive there? And essentially trying to distill the ideas why in Central and European countries we are facing such a problem of delays, I was thinking of two strands of ideas, really. Firstly, and that's the general sociological factor or societal factor, which is not only owed to the new member states or the transition Europe, which is owed to the entire system, entire Europe, is the gradual judicialization of all the questions and procedures. Right? You can see it, and you can see it in the West, in the literature, the increase of importance of courts and the amount of cases being litigated before courts. It kept rising ever since the Second World War in entire Europe, well, not to speak of the United States, who have been a bit strange always. But even in Western Europe, this kept rising continuously ever since the Second World War. I mean, there is a number of theories around there why other normative systems gradually failed, provide litigation and dispute resolution, morality, religion, professional self-administration, and so forth. These units, which functioned in the earlier times, in the socially cohesive societies, functioned as a dispute resolution bodies, stopped functioning. And we see the increase, Western Germany, France, other countries, ever since the Second World War, in the amount of litigation going through courts. Now the problem with communist Eastern Europe, Central and Eastern Europe, was that essentially this problem was naturally frozen during the communist times, because courts were not considered to be the place for solving disputes, right? If you had a problem, you wouldn't be primarily taking it to courts, because the real power and the real dispute resolution was somewhere else. Albeit, I mean, it's established by numbers that also in the Eastern Bloc in 1980s, the amount of litigation started gradually rising, but this wasn't that massive, right? One always knew, well, to court, one goes if I need a paper, right? I'm not going there for dispute resolution. I'm going there to get the bumashka, a stamp on something, divorce, whatsoever I need for the function, but I'm not really seeking court in order to protect my rights. I mean, in communist bloc, no one really believed that. The problem then comes in 1990s, when essentially the change, sociological change, which the Western countries have gradually grappled with since 1950s, comes within 1 decade. It's all concentrated, and it all comes in at once. And when I look at the figures in Poland, Hungary, Czech Republic in the 1990s, you see the amount of cases multiplying, right? By rising annually by 30%, 50%, and within the decade, for instance, in Poland, having 300, 400% rise in cases, in civil cases, not to speak of commercial, and so forth and so on. So you have this explosion of litigation, which the system obviously wasn't prepared for. That would be the overall sociological trend. To this comes, at least in certain Central European countries, the transition and transformation problems. I don't know about from. Enter? Hello.
Ne rabimo kabla. Ne ste ga zdaj. Kasneje se bomo dogovorili.
It's a matrix, you're not supposed to plug ourselves in.
That was part of the plan to interrupt you because you're too good.
I thought too quick, but around. Right, so the sociological transition in Central Europe is accompanied by the transition or transformation itself. What we had, especially in Czech Republic, also in Slovakia, not so much in Poland, a bit in Hungary, in 1990s is yet another massive increase in litigation due to restitutions, restitution of property, rehabilitation, privatization, and also in some countries, lustration laws. All these things which came on a bunch in the early 1990s were the complete congestion of the entire system. Why? Well, you started popping in, for instance, restitution of property disputes, which involved complex, extremely complex cases, often reassessing very ancient facts, going back to 1940s, 1950s, before the Second World War and so forth, proving citizenship, residence, title to property, and these were just a nightmare in terms of complexity of cases and evidence required, right? And it depended, this was different in between various states in Central Europe, in how far did they decide to do privatizations and restitution of property. Some didn't go that far, others, for instance, Czech Republic, went very far, so we started restituting a number of properties, and it was a nightmare. I mean, it yet again increased the amount of cases, adding the layer of complexity and reopening of old cases nobody really wanted. So that's the second element, meaning we started reopening on a massive scale, started reopening past cases or past facts because due to transition. Now, the third fact was an institutional one. In a number of countries, certainly in Central Europe, at the beginning of 1990s, the courts virtually emptied. Not entirely, but there was a huge turnover of staff within courts. Why? Well, because so far or until then, private practice was heavily regulated profession. In the early of 1990s, the gates opened. And obviously, for instance, in Czech Republic or Slovakia, private practice in early 1990s was the golden bonanza everybody was running for, including the more able judges, really. And I think the numbers for the Czech Republic and Slovakia are something that by 1995, you would have only something like 30 to 35% of judges sitting on a bench who would have been already before 1989. So partially, obviously, it was sort of self-cleansing, or cleansing partially, but not that much. With judiciary, we didn't do radical ruptures, right? So it was quite funny because I remember sitting in one of these, in early 1990s, still by that time being a law student, and I was invited, there was an English law lord coming to Prague. You must have had those as well, sort of missionaries coming from the West and saying how this is to be done. And there was an English law lord coming to the Czech Republic, and we had a dinner with him, to which I sort of accidentally was invited as well. And it was great fun because then I think it was the president of the Prague Municipal Court sort of asked him over dinner with a serious face, what are we supposed to do now? And the English law lord, who sort of, in a style of English humor, said, well, hang all the judges, really. And there was this silence before everybody else, oh, it's a joke. So, no, but in a way, it's very true, right? You have a system which, even though you wouldn't have politically exposed judges, you still have the entire mass of people and culture from under the old system. What do you do? Well, in this way, it's often portrayed these days that, oh, these terrible communist judges who sit in the courts, and they are the roots of all the malaise. It's not really true. At least in Central Europe, it's statistically not true. By 2000, only about 25 to 30% would be people sitting from before 1989. The vast majority would be fresh people. And that actually was part of the problem, which I list here as the third institutional problem. The loss of know-how, the loss of collective memory. Because if you have, and especially as the hierarchy judiciary works, on the lowest level district courts, you have the youngest people, and appellate and supreme level are the more older ones. So at the end of 1990s, when I would have come to a, district court for Prague 6, you wouldn't find anybody who would be longer than 4 to 5 years. Really. And that's also one of the problems when I'm not over-idealizing career judges before 1989, but certainly there are professionals in a way. And once you have this rupture and you lose the continuity, then obviously before those new people start getting on the top of the job, it takes some time. So, these three things, really sociological transformation plus institutional rupture, I think are really the major factors in arriving where we arrived, especially in the second half of 1990s in Central Europe, is essentially where you are desperate and you come to the court and you wait for a judgment for 4 to 5 years, or even longer in some cases. To this, what also adds another institutional factor, which I will be talking about in the second half, is really the question of the structure and the parachuting of the new institution called constitutional courts. Because obviously, as the narrative goes, especially the sort of liberal scholarship is, oh, these constitutional courts now bring in the rule of law and building a happy tomorrow of human rights and so forth. Yes, fine, I'm not denying that. But in terms of judicial delays and establishment and functioning of the system, constitutional courts, especially those who did have individual constitutional complaint, meaning the ability to review individual decision of highest courts or whatever other courts, all public power, especially 1990s, function as very disruptive elements. Because what happened, well, you had a case gone through the system, then it was annulled, ideally together with a piece of law on which it relied. It came back, and this, with 2 or 3 rounds, oh yes, you are in 15 years, right? So I'm not saying it's bad, and I'm not saying it could have functioned differently, but the additional layer of complexity, which we are still battling with till today, are really in themselves the constitutional courts. How do they fit into system? What are they supposed to do, especially what are they supposed to do after transition? We will be talking about it towards the end, hopefully. But this is the sort of big picture when I was thinking about, well, how did we arrive, where did we arrive, was pretty much, yeah, the combination of the societal elements, transformation input, plus the institutional and personal ruptures which were going on within the courts. Now, intentionally, I'm not mentioning as one of the factors the sort of academically very favored formalism and excessive positivism and so forth in courts, because I don't really believe it's a problem in terms of judicial delays. Right? Judicial delays are mostly really technical problem. Obviously, mentality and ideology of judges is very important. But in my point of view, in terms of disposing of a docket in a reasonable time frame, is secondary. Let me give an extreme example. I mean, if you were to take Dworkin and Hercules, I mean, may he rest in peace now, Dworkin, but still. If you were to take Dworkin and Hercules and put him to a, I don't know, district court in northern Bohemia in the 1990s, where he would come in his office and get as a welcome gift 3,000 pending criminal cases, then I think even Hercules would commit intellectual suicide within weeks. So the problem there is really not the ideology. Ideology we may start playing with later on, but if you are facing completely non-manageable docket and problem of workflow, then I suppose then you can, start playing with ideas later on, but hardly here at the beginning. Right, so, and then as I said, sorry to be jumping from one to the other, but as I said, I mean, constitutional courts and their introduction as sort of revolutionary tribunals which you parachuted within the new institutional structure in order to enforce the new constitutional settlement, in this way were very problematic. I mean, for instance, one of the terrific cases from the Czech judicial practice are restitutions. I mean, it has been an ongoing nightmare in terms of the constitutional court itself, gradually changing and deciding whether the conditions are constitutional, whether the procedure is constitutional, whether you should have or should not have requirement of citizenship and residence, whether and according to which procedure this is to be done, and so forth and so on. And once you change these rules of the game 2 or 3 times over a decade, it's a complete chaos. The cases need to be reopened, and obviously all this is a cascading effect or domino effect, right? You throw down one case, and because being bound by the legal opinion in all the running cases which are still within the system, then you may restart and so forth. I mean, I don't know about Slovenia, but normally in the sort of Germanic tradition, a change in legal opinion of the Supreme Court is not a sufficient ground for reopening. So you cannot go across res judicata if it's a final decision, even though later on a constitutional court or a Supreme Court may decide that the law was wrongfully applied. Even a constitutional court who may annul the law on which the decision was previously based, you cannot reopen. However, this has repercussion into all these cases which are still alive, which typically in these cases will be hundreds or even thousands of pending litigation. Right, so this is the picture of something like 1990s, at least in Central Europe, where the combination of the factors we have been briefly examining caused for a complete, I mean, effective really breaking down of the system, where you would be sitting there and, well, justice was very remote. It actually depended according to the area. I mean, civil justice was quite a problem. Commercial cases, oh, forget about it. Criminal justice in a way functions still, because, I don't know, the criminal people are somewhat strange, but still they manage. Administrative review was sort of illusionary. And all took immense amount of time. So, what now, or what was the way forward in terms of trying to change a bit and to get the judicial delays into a reasonable time frame? What I mean by reasonable time frame is obviously very subjective, right? To give an example yet again from the administrative justice in the Czech Republic, when the Supreme Administrative Court was established in 2003, it would have inherited several thousands, 10,000s of cases, plus because some, excuse me, stupid legislative person drafted the law on asylum in a terrible way, giving automatic suspensory effect to every cassational complaint brought against the decision not to grant asylum, meant that within a few months we've got something like 15,000 asylum cases as well on the top, which is great. So you would have 10,000s of cases facing, and obviously the length of procedure by that time would be something like two to 3 years in one instance. Within the decade, with successive revisions and fine-tuning of the system, for instance, administrative justice now is at the stage where first instance will be within the year, and the second instance, meaning the revision before the Supreme Administrative Court, is generally 6 to 8 months. So you get a case completely through the system within 2 years, which are just 2 instances, right? After that comes the congestion called the Constitutional Court, but the system itself functions quite reasonably at this stage. Yet again, reasonably is subjective. I think a year for a first instance decision is still quite a lot, but yeah, well, you have to work with what you've got. Okay, the way forward are just some ideas on reforms and suggestions. Yet again, no blueprint, just ideas. I've divided into 3 sort of areas. Firstly, looking at first instance courts, so trial courts, then appellate courts, Supreme Court, and Supreme Constitutional Court at the end. However, before going at the respective level of courts, one idea I would like to put sort of in the front of the brackets, really. And that's the following one. A functional judicial system must function as a system. I know it sounds banal. It's so banal as to border on the stupid, but it's very important. Why? If I have a system or a judicial hierarchy where the individual levels of the hierarchy don't recognize their respective function and place, I arrive at a system where everybody's claiming to do everything, but nobody does it properly. And the guiding principle of the judicial systems are then sort of turf wars in between the Constitutional Court and the Supreme Court and Appellate Court, and everybody's kicking everybody down, but the system does not function. A functional judicial system starts evolving when I have a functional division of labor in between the various echelons of the hierarchy. And I have a mutual respect or symbiosis. Right? The lower respect the upper echelon, and vice versa, actually. I don't have the sort of stupid post-communist kicking, which I see in a number of cases in Central Europe, where because they are down, I really must kick their hat, because they are completely stupid and they don't understand it. And vice versa. I'm not respecting the Obrigkeit because they are terrible. We see, or at least I see, a number of such sort of turf wars within the Czech judiciary, within the Slovak judiciary, it's even worse. And the problem is, then I don't get a functional system, because the various echelons and units don't function as a system. Now, what do I mean by the system in concreto? I mean, in the concrete idea. Well, firstly, I mean, looking at an ideal continental model of judicial hierarchy, right? Leaving apart the Anglo-American style, which is very, but which is quite far from the continental hierarchical judiciary. Well, firstly, first instance ought to be the most important court. Most important in terms of focusing on file, on the individual dispute, on the facts of the case in quite some detail, and being responsive to all the arguments raised by the parties. That's where the individual justice ought to be done. That's why, I mean, And really, this is the individual contact, which then spills over into requirements as regards justification and judicial style, being explicatory, trying to be understandable even to a like person, and so forth. But this is really the direct point of contact between, or ought to be, between the individual and the judicial system. Appellate courts, I mean the second level courts, are essentially revision courts, which on the one, if you will, with one foot, they are still standing in the individual dispute and very closely